So here's the deal. You ever heard of a case called U.S. versus Landros?
Yeah.
That case out of Arizona? It's the one where involving that traffic stop and the passenger with the ID issue?
Yes.
Okay. So the reason I bring that up is because I want to share with you a little bit of what happened. So this one came in fresh off the presses. Okay. It's still kind of the laser print is still wet.
Let me touch it with intent to gather information there.
Oh, you do? You want to trespass on my papers?
Yeah.
So this is an officer from Pocatello Police Department, Idaho. He says, can we force identified passengers under case law? So he says, hey, look, there's this case out of Idaho called Wharton versus Idaho. And you may not know that case, but I had to read it today. And it's contradicting a U.S. versus Landros case from the Ninth Circuit.
Okay.
Now, it seems like, he's basically saying, hey, can we ask for ID from passengers? Can we force ID? And I don't know what to do. So, all right. Do you know enough about Landros to tell the audience what Landros is about? And give me a Reader's Digest.
Guy that the truck guy wrecked in the ditch guy, or am I thinking of something?
No, you think about something else.
About something else.
Okay, let me tell you what happened on Landros. This will jog your memory. So what happened here is an Arizona tribal officer, I think, it doesn't really matter, but a tribal officer stopped a vehicle for traffic, and he wanted ID from Landros, who's the passenger.
The girls in the back.
The girls were in the back.
Girls in the back. There we go.
And so, but he didn't articulate that. He just basically said, hey, I want your ID. Landros is like, I didn't do anything wrong. Like, leave me alone type stuff. And he says, no, I'm going to, you have to ID under Arizona state law, which is, Arizona is a stop and identify law, right? So if you have reasonable suspicion, you can compel somebody to identify. And so is Nevada, where we're at right now. Well, he ends up arresting Landros for that obstruction. And when he goes to the court, he gives that lame ass excuse of, well, it's for officer safety. That's the way I do business type of stuff. Does that work in 2023?
No, not at all. Not at all.
Now, do you remember enough facts about the case? Because actually, when you look at it, Landros could have actually compelled his ID. Do you remember why?
Could have compelled it?
Yes.
Well,
in my view.
So are you talking about with the
young girls?
With the involvement of the young girls, right? Because he believed them to be under the intoxication of alcohol.
Bingo.
Right? And believed them to be under 21.
That's right.
So then if that's the case, well, then now you've got reasonable suspicion to believe that there's contributing to minors. There's an investigation to be done, right?
Man, that's so great, because isn't that something that we see all the time, right? We see officers really doing, like, they're doing good police work, like they're doing the right thing. But when it comes to the report, they stink. Yes, and nobody everybody wants to run and gun, right? But nobody wants to run and write. Like, I mean, it sucks, right? I mean, I get it.
Oh yeah.
But isn't the police report like maybe the most important part of the actual investigation?
Absolutely.
Okay.
Absolutely.
And you were talking about that. In fact, you had a webinar just before this webinar called CIs and Search Warrants. And you can also watch that on YouTube, by the way, for the people watching on YouTube. So it's gonna be posted probably later tonight when it uploads. And you said, I thought it was kind of interesting. You said there was a very powerful word in the police report. What word was that?
Because.
Right.
It's the word because. It makes you explain what you just said.
And it's like, so when cops say, I pat the person down because I believed he was armed and dangerous, right? That's not enough. I believed he was armed and dangerous.
Because.
Right, because of all these factors. So going back to Landros, he was, the Ninth Circuit said that your rationale, and just make sure you keep, and Rick, the producer, if you see any questions or anybody wants a mic, can you just let us know too? And so he compels this ID. He makes the arrest. It's a bad arrest because the rationale he's not doing is justified. But here's the kicker: not only could he have identified because the women, they were underage, intoxicated. When they got him out of the car, they actually found the bottle of booze hidden under his legs. So he was contributing to a minor. Now let's go back to Wharton. Wharton is a case where, in fact, I might actually have a little something printed out. But Wharton is a case where the officer asked a passenger for his ID.
Okay.
And he ran the guy and he came back with a warrant, search, instant to arrest. We find evidence. Now, do you think that violates what we're talking about in Landros?
In Landros, no. Ask, fine.
Yeah.
Consent, right?
You consent. Now, what's interesting too, this is a case from 2022. I've always been cautious, at least for my officers of the Ninth Circuit, to be careful about running people and adding time.
That's the why they kind of like
the
ask part, okay.
But now, just so you know, Idaho is saying good to go.
No concerns about any
No, they
extension?
said that actually it's part of a traffic stop because it's officer safety.
Okay.
And it also adds a negligible amount of time. And what's interesting is that the Ninth Circuit has started using that language in another case called United States versus Taylor 2023, where if you're just adding a negligible amount of time, then it's not going to violate the U.S. Supreme Court restrictions on prolonging a stop. Now,
would you intertwine negligible with reasonable?
Reasonable, yes, and also yes, reasonable. And I don't want to use the word de minimis because de minimis is a doctrine that says it's so minimal that we can't complain about it. But it's also just like I do believe that if you ask a passenger for their ID, that two things are going on. Number one is maybe they are implicitly consenting to be run, because that's what cops want to do with IDs.
Argument for it, yeah.
But also, I do think it's rationally related to the traffic stop. I mean, if you got a person who's a fugitive for murder, I do think that's something that we should know during a routine traffic stop.
And I mean, I've read tons of cases where the courts are always hold in high regard the inherent dangerousness of traffic stops, and the unknown of the persons inside that vehicle has always been a concern of the courts for us. Okay,
so now what I like to teach in my classes is, hey, fine, you stop a car with a couple people in it, you got a driver, passenger, maybe two passengers, you run them. Okay, according to Wharton, I kind of dig it, I like it. If you want to run them, it shouldn't really run afoul of the Fourth Amendment. I do agree with that, by the way. But what about 6 people? 7. What about a passenger van? What about a Greyhound bus? I mean, so there might be a limit to it.
Yeah, then you start getting measurably extending.
Yeah. All right.